For 10 years, I gave up everything. My career. My marriage. My 20s. I slept on a cot next to my mother's bed. I learned how to change 4 lines. I memorized every medication, every dosage, every side effect. And when she finally closed her eyes for the last time, my brother walked in, handed me a piece of paper and said, "The house is mine. The accounts are mine. Mom wanted it this way." He hadn't visited in 6 years. Not once. My name is Emily Hartwell. I'm 38 years old, from Charleston, South Carolina. And what happened next, inside that courtroom, changed everything I believed about family, loyalty, and the law. This is my story. Let me take you back to 2013. I was 27 years old. I had just started a promising job at a marketing firm in downtown Charleston. I had an apartment I loved, a relationship I was building, and for the first time in my life, I felt like things were going exactly where I wanted them to go. Then my mother called. Her name was Carol Hartwell. She was 61 years old, and she had just been diagnosed with early-stage Parkinson's disease. Now, if you know anything about Parkinson's, you know it doesn't stay early stage for long. It progresses. Slowly at first. Then faster than you're ready for. My mother's doctors in Charleston were honest with us from the beginning. They said she would eventually need full-time care. My brother, Ryan Hartwell, lived in Seattle, Washington. He was 34 at the time, 7 years older than me. He had a good job in tech, a nice apartment, and what I now understand was absolutely zero intention of disrupting his life. So the conversation happened exactly the way you'd expect it to. Mom called us both on a Sunday evening. Ryan was on speakerphone. She explained the diagnosis. There was a long silence. And then Ryan said, and I will never forget these exact words, "Emily's closer. It makes more sense for her to handle things." Handle things. That's what he called our mother's life. Things. I should have said no. I know that now. But I was 27, I loved my mother, and I genuinely believed that Ryan would step up when it really mattered. He didn't. I gave up my apartment. I moved into my mother's house on Magnolia Drive, a beautiful old house, 3 bedrooms, built in 1974. My parents had bought it together in 1988. My father passed away in 2009, and after that, the house was everything to my mother. It was her memories, her garden, her life. I quit my job after the first year. Mom's condition had progressed faster than the doctors expected. She needed help getting dressed, help with meals, help getting to the bathroom at 3 in the morning when her legs wouldn't cooperate. I was there for every single moment of it. Ryan called on holidays. Sometimes. He sent a card on her birthday most years. In 2016, he visited for 4 days. 4 days in 3 years. He spent most of it on his laptop in the guest room. I'm not going to pretend those years weren't hard. They were the hardest years of my life. I watched my mother, this strong, independent woman who used to grow her own tomatoes and teach Sunday school, slowly lose the ability to do the things she loved. But there were beautiful moments too. We watched every season of The Golden Girls together. She told me stories about my father I had never heard before. She taught me how to make her cornbread recipe from memory, because she said, "Emily, my hands don't work right anymore, but yours do." I held her hand through every doctor's appointment, every bad night, every moment of fear and confusion and grief. And through all of it, I never once thought about the house. I wasn't there for the house. I was there for her. But Ryan, it turns out, had been thinking about the house for a very long time. In January of 2022, my mother's condition entered what her doctors called the advanced stage. She was having trouble swallowing. She was sleeping most of the day. We had brought in a hospice team, and they were wonderful, but everyone understood what this meant. It was almost time. That's when Ryan showed up. Not for a visit. Not to say goodbye. Not to sit with her and hold her hand the way I had been doing for 9 years. He showed up with a man I had never met. A man in a gray suit, carrying a briefcase. He introduced himself as a notary. I asked Ryan what was going on. He smiled, this calm, practiced smile, and said, "Mom just wants to update a few things. Estate planning. Nothing to worry about." I was confused. Mom had a will. She had made it years ago, when she was healthy, when her mind was clear. She had told me directly, that the house would be split equally between Ryan and me. Everything else too. I asked if I could be in the room. Ryan said it was a private matter between him and Mom. He closed the bedroom door. I stood in the hallway of my mother's house, the house I had lived in for 9 years, the house I had cleaned and repaired and maintained, and I stood there listening to the sound of my mother's weak voice, and a man's voice asking her questions, and the scratch of a pen on paper. 20 minutes later, Ryan walked out with a folder under his arm. He didn't look at me. 3 weeks later, my mother passed away peacefully in her sleep. And 2 days after the funeral, before I had even begun to process my grief, Ryan handed me a document. A new will. Signed 6 weeks before her death. Everything, the house, the bank accounts, the savings, all of it, went to Ryan Michael Hartwell. My name wasn't in it. Not once. For those of you who are back, you already know what Ryan did. He walked into our dying mother's bedroom with a notary, closed the door in my face, and walked out with a document that erased me completely. I stood in that hallway holding a piece of paper that said, "After 10 years of my life, I got nothing." But here's what Ryan didn't know. He didn't know that I had spent 9 years paying attention to every single detail of my mother's life. Her medications, her moods, her good days and her bad days. And I knew with absolute certainty, that in the final weeks of her life, my mother was not capable of making that decision on her own. What I didn't know yet, was how to prove it. The week after the funeral, I couldn't sleep. I would lie in the guest bedroom. Ryan had already told me I needed to make arrangements to move out within 30 days, and I would stare at the ceiling of the house I had lived in for 9 years, and I would go over everything in my mind. The gray suit, the briefcase, the closed door, Ryan's practiced smile, the scratch of a pen. Something was deeply wrong. I could feel it the way you feel a storm coming before the sky changes color. On a Tuesday morning, I drove to the public library on Calhoun Street in Charleston. I didn't want to use my home internet, which is a strange thing to think about, I know, but something told me to be careful. I spent 4 hours reading everything I could find about will contests in South Carolina. About undue influence. About testamentary capacity, which is the legal term for whether a person was mentally capable of signing a legal document at the time they signed it. And what I found gave me the first real breath of hope I had felt since the funeral. In South Carolina, and in most states across the country, a will can be challenged if you can prove that the person who signed it did not have the mental capacity to understand what they were signing, or if someone used pressure, manipulation, or deception to influence them. My mother, in her final 6 weeks, was on a combination of medications that her doctors had told me could cause confusion. She was sleeping 16 to 18 hours a day. There were mornings when she didn't know what year it was. I had witnessed all of it. And I had something Ryan didn't know about. I had records. For 9 years, I had kept a caregiving journal. It started as just a way to track her medications and appointments, but over time it had become something more. Every night before I went to sleep, I would write down how she had been that day. What she had eaten. How she had slept. What she had said. Whether she had seemed confused or clear. I had filled 11 notebooks. 11 notebooks, sitting in a box in my closet. Ryan had no idea they existed. I drove home, went straight to my closet, and pulled out that box. I opened the notebook from December 2021, 6 weeks before the will was signed, and I started reading. December 4th, Mom didn't recognize the hospice nurse today. called her by Aunt Patricia's name 3 times, seemed distressed when corrected, gave her the 6 p.m. medication at 5:45. She asked me twice if she had already taken it. December 11th, bad night. Mom woke up at 2 a.m. convinced it was 1987 and Dad was still alive. Sat with her for 2 hours. She was calm by morning but exhausted. December 19th, doctor called to check in. Mom struggled to answer basic questions during the call, couldn't remember the current president, wasn't sure of the month. Doctor noted this in her chart. I sat on the floor of my closet and I read for 3 hours straight. By the time I finished, I had highlighted 23 separate entries, all from the 6 weeks before the will was signed, documenting my mother's confusion, her memory lapses, her inability to process information clearly. This was my evidence. Now I needed someone who knew what to do with it. I called 7 attorneys in the first week. 3 didn't call back. 2 said they didn't handle will contests. 1 told me the case sounded too complicated and too expensive. The 7th one, a woman named Patricia Okafor, whose office was on King Street in downtown Charleston, asked me to come in the next morning. I almost cried when she said that. Patricia was in her mid-50s. Sharp eyes. Quiet voice. The kind of person who made you feel, from the first moment, that she had seen everything and nothing surprised her anymore. I brought the 11 journals. I brought the original will, the one my mother had made years earlier when she was healthy. I brought every medical record I had. Every prescription. Every doctor's note. I laid it all out on her conference table. Patricia was quiet for a long time. Then she looked up at me and said, "Emily, I need you to understand something before we go any further. Will contests are hard. They are expensive, they are emotionally draining, and they are not guaranteed. Even with everything you've brought me today, and this is more than most people bring, your brother is going to fight back. Hard. Are you prepared for that?" I told her I had spent 10 years preparing for hard things. She almost smiled. She took the case. Over the next 3 weeks, Patricia filed a formal contest of the will in Charleston County Probate Court. The legal claim had 2 parts. First, lack of testamentary capacity. We were arguing that my mother, at the time she signed the new will, did not have the mental clarity required by law to understand what she was doing. Second, undue influence. We were arguing that Ryan had used his position of authority, showing up at a vulnerable moment, bringing a notary, closing the door, keeping me out, to pressure our mother into signing something she would never have signed if she had been well. Ryan hired an attorney the same week. His name was Jeffrey Marsh. He was expensive, and he was aggressive, and his first move was to send me a formal letter demanding I vacate the property within 14 days. Patricia filed an emergency motion to let me stay in the house until the case was resolved. The judge granted it. Round 1, Emily. But we both knew the real fight hadn't even started yet. 3 weeks into the case, Patricia called me at 8 in the morning. Her voice was different. Controlled, but different. She told me to come to her office right away. When I got there, she had a document spread across her desk. It was part of the discovery process, the legal procedure where both sides have to share evidence with each other. Jeffrey Marsh's team had submitted the notary's records. Patricia pointed to a specific line. The will had been signed on January 14, 2022. The notary's name was listed as Harold Simmons, a licensed notary from Columbia, South Carolina, 2 hours away from Charleston. I asked why that mattered. Patricia leaned forward. Because Harold Simmons is not just any notary, Emily. He's listed on the website of a legal services firm in Columbia, a firm that has done work for your brother's company in Seattle 3 times in the past 4 years. I stared at her. Ryan didn't find a random notary, she said. He brought his own guy. Someone he already had a relationship with. Someone he trusted to do exactly what he needed done, no questions asked. The room felt very still. This wasn't just a brother taking advantage of a dying mother's confusion. This was planned. Ryan had planned this. The question now was, how long had he been planning it? And was there anything else he had done that we didn't know about yet? Patricia had already filed a subpoena for my mother's bank records going back 2 years. We were about to find out exactly what Ryan Hartwell had been doing while I was sitting by our mother's bedside at 3 in the morning. And what we found in those bank records was worse than anything I had imagined. The bank statements arrived on a Thursday afternoon. Patricia called me as soon as she had gone through them. I could tell by the silence before she spoke that it was bad. "Emily," she said. "In the 14 months before your mother passed away, 14 months, there were 31 separate wire transfers out of your mother's savings account. Total amount withdrawn, $147,000. Every single transfer went to the same account. Your brother's." I sat down on the kitchen floor. $147,000. Gone. While I was changing her medications and holding her hand through the night, Ryan had been systematically draining our mother's life savings. And he had done it so carefully, so quietly, that I never saw it coming. Patricia's voice was steady and calm when she spoke again. "Emily, this is no longer just a will contest. What your brother did, this is financial elder abuse. It's a civil matter and potentially a criminal one. I need you to prepare yourself, because when we walk into that courtroom, we are going to expose every single dollar." I looked around the kitchen. At the cornbread pan hanging on the wall. At the little ceramic rooster my mother kept on the windowsill since 1995. At the garden outside that I had watered and weeded for 9 years. This was my mother's home. And I was going to fight for it. Every single dollar. Every single entry in those 11 journals. Every late night, every early morning, every moment Ryan spent in Seattle while I was here. I was going to bring all of it into that courtroom. The hearing was set for April 3rd. I had 6 weeks to prepare. Part 3 is coming, and that's where we walk into the courtroom together. Make sure you're subscribed so you don't miss it. And if you've ever had a family member betray your trust, drop a comment below. I read every single one. Your comments kept me going through the hardest weeks of this entire process. So many of you have shared your own stories of family betrayal, of caregiving without recognition, of watching someone you love be taken advantage of. I read every single one. This part 3, is the one you've been waiting for. The courtroom. I want to tell you right now, it was nothing like I expected. It was harder. It was more painful. And at one point, I genuinely did not know which way it was going to go. But I promised you the truth. All of it. So, let's go back to April 3rd. I woke up at 4:47 in the morning on April 3rd. I hadn't set an alarm. My body just woke itself up, the way it used to during the years when Mom needed me in the night. Some part of my nervous system had never fully unlearned that habit. I lay there in the dark for a long time. I thought about the 11 journals stacked in Patricia's office. I thought about the bank records. I thought about Harold Simmons, the notary Ryan had brought from Colombia, and the quiet, deliberate way my brother had planned all of this. I thought about my mother. I thought about the last real conversation we had about 3 months before she passed, on a good afternoon when her mind was clear and the winter sun was coming through the kitchen window. She had reached out and taken my hand and said, "Emily, I don't know what I would have done without you. You gave up everything for me. I hope you know that I see that. I see every single thing you've done." I held on to that memory like it was something physical. Then I got dressed, made coffee I didn't drink, and drove to the Charleston County Probate Court on Broad Street. Patricia was already there when I arrived. She was standing outside the building in a dark blue blazer, going over notes on her legal pad. She looked up when she saw me, and she gave me a small, firm nod. "You ready?" she asked. I told her I had been ready for 10 years. Ryan was already inside. I saw him through the glass doors before I walked in. He was sitting with Jeffrey Marsh at the respondent's table, expensive suit, hair neatly combed, the same practiced calm on his face that he had worn the day he closed our mother's bedroom door. He didn't look at me when I walked in. That told me everything I needed to know about his conscience. The courtroom was smaller than I had imagined. Wood paneling. Fluorescent lights. A handful of wooden benches for observers, a few of which were occupied by people I didn't recognize. Probably other cases waiting their turn. Patricia and I sat down at the petitioner's table. The judge entered at exactly 9 a.m. Her name was the Honorable Judge Diane Calloway. She was a compact woman in her 60s with silver hair pulled back and reading glasses on a chain around her neck. She moved with the quiet efficiency of someone who had presided over thousands of difficult days in other people's lives and had long since stopped being surprised by any of it. She settled into her chair, reviewed her papers for a moment, and looked up. "We are here today in the matter of the estate of Carol and Hartwell," she said. Petitioner Emily Hartwell is contesting the validity of a will dated January 14, 2022, on the grounds of lack of testamentary capacity and undue influence. Is petitioner's counsel ready? Patricia stood. "Ready, Your Honor." Is respondent's counsel ready? Jeffrey Marsh stood, smooth and unhurried. "Ready, Your Honor." Judge Calloway set down her glasses. "Then let's begin." Patricia's opening statement was 8 minutes long. She didn't raise her voice once. She laid out the timeline clearly and without emotion. The 9 years of caregiving, the progression of my mother's Parkinson's, the medical documentation of her cognitive decline in the final weeks, the sudden appearance of Ryan with a notary in January, and the $147,000 in wire transfers that had been quietly moving from our mother's account to Ryan's for over a year. She held up the 11 journals. "Your Honor, for 9 years, Emily Hartwell documented her mother's condition every single day. These journals are not legal documents. They were never intended to be used in a courtroom. They were the private record of a daughter trying to take care of her mother as well as she possibly could. And it is precisely because of that, because they were never meant to be evidence, that they are the most honest record we have of Carol Hartwell's state of mind in the final months of her life." She set the journals down on the table. "We will show that on January 14, 2022, Carol Hartwell did not have the cognitive capacity required by South Carolina law to execute a valid will. And we will show that her son, Ryan Hartwell, knew this and used it." She sat down. Jeffrey Marsh's opening was 12 minutes long and very polished. He argued that my mother had been having good days and bad days, as Parkinson's patients often do, and that January 14th had been a good day. He argued that the will was witnessed by a licensed notary, who could testify to my mother's apparent understanding. He argued that my 9 years of caregiving, while admirable, did not give me legal authority over my mother's wishes. And then he said something that made my hands go cold under the table. The petitioner would have this court believe that Carol Hartwell, a woman who raised 2 children, managed her own finances for decades, and lived independently until the final stage of her illness, was somehow incapable of deciding how to distribute her own estate. The truth is simpler than that. Carol Hartwell made a choice. Her daughter simply doesn't like it. I kept my face completely still. Patricia had prepared me for this. She had told me they would try to make it personal. She had told me not to react. I breathed slowly and looked straight ahead. "Don't give them your emotions," she had said. "Save them for the journals." Patricia called 3 witnesses. The first was Dr. James Whitfield, my mother's neurologist at the Medical University of South Carolina. He had been treating her for 6 years. Patricia walked him through my mother's diagnosis, her progression, and the specific medications she had been on in the final months of her life. Then she asked him the question the entire case depended on. Dr. Whitfield, in your professional medical opinion, based on Carol Hartwell's condition in January of 2022, her medication regimen, and the documented progression of her illness, would she have had the cognitive capacity to understand the nature and consequences of signing a new legal will? Dr. Whitfield was quiet for a moment. In my opinion, he said carefully, it is highly unlikely. Mrs. Hartwell was in the advanced stage of Parkinson's disease. She was experiencing significant cognitive fluctuations, what we call Parkinson's disease dementia. On her worst days, she was not oriented to time or place. On her better days, she could hold a conversation, but would often lose the thread of complex information. Understanding the full implications of a legal document, what she owned, who she was giving it to, what she was changing and why, would have required a level of sustained cognitive clarity that, in my assessment, she no longer consistently had. The courtroom was very quiet. Jeffrey Marsh cross-examined Dr. Whitfield for 20 minutes, pressing him on whether he had personally evaluated my mother on January 14, specifically. Dr. Whitfield acknowledged he had not. Marsh made sure the judge noticed that. Patricia's second witness was Margaret Ellison, Mom's hospice nurse, who had been visiting the house 3 times a week in the final months. Margaret was a soft-spoken woman from Somerville with 30 years of hospice experience. She described my mother's condition in January with quiet, clinical precision. She remembered the week of January 14, specifically because she had noted in her own records that my mother had been markedly confused during her visit on January 12, 2 days before the will was signed. She called me by her sister's name, Margaret said. Her sister passed away in 2008. She asked me if I had heard from her lately. Jeffrey Marsh's cross-examination of Margaret was brief. He asked whether 2 days of confusion necessarily meant confusion on January 14, specifically. Margaret said she could only speak to what she had personally observed. Marsh nodded and sat down. Patricia's third witness was me. I had practiced my testimony with Patricia 6 times over the past 3 weeks. She had sat across from me at her conference table and asked me every question she planned to ask in court, and then she had played Jeffrey Marsh and asked me every question she thought he would ask. She had made me do it again when my voice broke, and again when I got angry, and again until I could answer every question calmly, clearly, and without giving Marsh anything he could use. I took the stand. Patricia started with the basics. Who I was. When I moved in with my mother. What my daily caregiving responsibilities had looked like. How my mother's condition had changed over the years. Then she picked up one of the journals. Emily, can you tell the court what this is? I explained the journals. Why I had started keeping them. What they contained. Patricia opened to a specific page. I'm going to read a passage from your journal dated January 13, 2022, the day before the contested will was signed. Can you confirm this is your handwriting? Yes. She read it aloud. Mom had a very difficult night. She woke up 3 times. At 2 a.m. she was convinced the house was on fire and became very distressed. It took almost an hour to calm her down. In the morning she was exhausted and disoriented. She did not recognize the hospice aide who came at 10 a.m. When I asked her what she would like for lunch, she looked at me for a long moment, and then said, "Where is your father? He should be home by now. Dad passed away 13 years ago." Patricia closed the journal. The courtroom was completely silent. "Emily," she said quietly, "on the following day, January 14th, were you present when the will was signed?" "No. Ryan asked me to leave the room." "Did your mother ask you to leave?" "No. In your 9 years of caring for your mother, did she ever ask you to leave the room during any medical, legal, or financial matter?" "Never." Patricia nodded slowly. No further questions. Then Jeffrey Marsh stood up. And the next 40 minutes were the hardest 40 minutes of my life. Marsh was good. I want to be honest about that. He didn't attack me the way I had feared. He was too smart for that. Instead, he was methodical and pleasant, the way a surgeon is pleasant before they cut. He started by acknowledging my caregiving. He said it was clear I had loved my mother deeply and had made enormous sacrifices. He said that was not in dispute. Then he slowly, carefully began to suggest that my grief, my very real, very understandable grief, had made it impossible for me to accept my mother's wishes. Isn't it possible, he said, that your mother, on a good day, simply made a decision you weren't expecting? Based on what I observed, no, but you weren't in the room, were you? Ryan made sure of that. So you don't actually know what was said between your mother and the notary. I know what my mother was like the night before. You know what she was like at 2 in the morning. Not at 2 in the afternoon when the will was signed. I took a breath. I know that a woman who didn't recognize her own hospice aide in the morning was not capable of understanding a legal document in the afternoon. Marsh paused. Then he shifted. He brought up the original will, the one made years earlier, when my mother was healthy. He pointed out that in that will, Ryan had also received a significant share of the estate, not nothing. Your mother clearly loved both of her children, he said. Isn't it possible she simply changed her mind about the distribution? My mother would not have changed her mind without telling me. How can you be certain of that? I looked at him steadily. Because she told me everything. For 10 years, I was the only person she saw every single day. She told me about her fears and her regrets and her wishes. She told me stories about her marriage I had never heard. She told me she wanted to be buried in her blue dress. She told me she wanted yellow roses at her funeral, not white. My mother did not keep things from me, especially not something this important. Marsh was quiet for a moment. Then he asked one final question. Ms. Hartwell, is it possible that you simply cannot accept that your mother may have wanted something different than what you expected? I looked at him. Then I looked at Ryan. Ryan was looking at the table. My mother, I said, spent the last night of her conscious life calling out for my father, who had been dead for 13 years. That is what she was like the day before she signed that document. So no. I cannot accept it, because it isn't true. Marsh sat down. Patricia did not re-examine me. She didn't need to. Jeffrey Marsh called 2 witnesses. The first was Harold Simmons, the notary. He was a thin man in his 60s who spoke carefully and kept his eyes on Marsh rather than the judge. He testified that on January 14th, my mother had appeared to understand what she was signing. That he had asked her standard questions. That she had answered them. Patricia's cross-examination was short and precise. She established his professional connection to Ryan's company in Seattle. She asked him how many times he had worked with businesses associated with Ryan Hartwell. He said he wasn't sure of the exact number. She showed him the records. 3 separate engagements. All paid through Ryan's company account. She asked whether he had disclosed this relationship to my mother before she signed. He said it hadn't come up. She asked whether he considered it a conflict of interest. He said he was just there to verify a signature. Patricia thanked him and sat down. The second witness was Ryan. He took the stand and he was composed and articulate, and he described our mother with great warmth. He talked about how much he had loved her. He said the distance between Seattle and Charleston had been painful for him. He said he had called as often as he could. He said that on January 14th, his mother had been having a good day. That she had been clear and calm. That she had told him she had been thinking about the will for a long time and she wanted to make some changes. He said she had told him, "Ryan, you're the oldest. The house should go to you. I've thought about this. I know what I want." He said it with complete conviction. I watched the judge's face while he spoke. Judge Calloway was writing something. Then Patricia stood for cross-examination. And she asked Ryan about the money. "Mr. Hartwell, during the 14 months prior to your mother's death, were you aware of any wire transfers from your mother's savings account to your personal account?" Ryan's composure held. "My mother asked me to help manage some of her finances. She trusted me with that. She asked you to transfer $147,000 out of her savings account? It was done with her knowledge and consent. Do you have any written documentation of that consent? Any email, any text, any signed authorization. A pause. It was a verbal arrangement. A verbal arrangement. Patricia let that sit for a moment. Mr. Hartwell, the medical records show that your mother's cognitive capacity was significantly diminished during this 14-month period. Are you telling this court that a woman who was documented as not recognizing her own hospice nurse verbally authorized you to move nearly $150,000 out of her life savings? Ryan's jaw tightened. She trusted me. Did she know what she was authorizing? Yes. Were you aware that financial exploitation of a vulnerable adult is a crime in the state of South Carolina? Jeffrey Marsh was on his feet immediately. Objection. Your Honor, counsel is withdrawn, Patricia said calmly. She looked down at her notes. Then she looked back up at Ryan. No further questions. The silence in that courtroom was unlike anything I had ever experienced. Ryan stepped down from the stand. He finally looked at me as he walked back to his seat. It was the first time he had looked at me all day. I didn't look away. Both attorneys gave their closing arguments after a short recess. Patricia was calm and methodical. She walked Judge Calloway through every piece of evidence one more time. The medical records. The journals. The notary's conflict of interest. The $147,000. The timeline of Ryan's actions, showing up only when there was something to gain. Bringing his own notary, keeping me out of the room. She ended with something that I hadn't expected. She talked about caregiving. Emily Hartwell spent 10 years of her life, her 20s and her 30s, caring for her mother. She did not do it for money. She did not do it for recognition. She did it because Carol Hartwell was her mother and she loved her. The law exists, in part, to protect people like Carol Hartwell, vulnerable people in the final stages of illness, from being exploited by those they trust. What Ryan Hartwell did in that bedroom on January 14th was not an act of love. It was an act of calculation. And this court has the power to say, that is not what justice looks like. Jeffrey Marsh's closing was strong. He argued that the evidence of incapacity was circumstantial. That Harold Simmons was a licensed professional who had done his job. That my mother had the legal right to change her will at any point in her life. That grief was not evidence. Then Judge Calloway said she would take the matter under advisement and issue a ruling within 2 weeks. 2 weeks. I had to wait 2 more weeks. I drove home that evening and sat in my mother's kitchen for a long time. I looked at the ceramic rooster on the windowsill. I talked to her. I told her I had done everything I could. I told her I hoped it was enough. 14 days later, Patricia called. It was a Thursday morning. Early. The kind of Charleston morning where the air is already warm before 8 a.m. and the light comes in golden through the kitchen window. My phone rang at 8:17. Patricia. I answered before the second ring. She was quiet for just a moment, and in that moment my entire body went still. Then she said, Emily. Judge Calloway issued her ruling this morning. I couldn't speak. She found in your favor. I put my hand over my mouth. On both counts. Lack of testamentary capacity and undue influence. The January 14th will has been declared invalid. The original will is reinstated. The house is yours. And Emily, she paused. She's referring the matter of the wire transfers to the Charleston County Sheriff's Office for potential criminal investigation. I sat down on the kitchen floor. The same kitchen floor where I had sat the night Patricia told me about the $147,000. The ceramic rooster was on the windowsill. The cornbread pan was on the wall. The garden outside was starting to bloom. The roses my mother had planted in 1991 were coming back, the way they always did, no matter the winter. I sat there on that floor, and I cried for a long time. Not from sadness. For the first time in what felt like forever, I cried, because something was right. Because 10 years of showing up, 10 years of journal entries and 3 a.m. wake-ups and medications, and hospice nurses and love, so much love, had mattered. The law had seen it. The judge had seen it. And somewhere, I have to believe this, my mother saw it too. This is the end of my story. But it's not the end of everything. In the final part, part 4, I'll tell you what happened next. What happened to Ryan? What happened to Harold Simmons? What the criminal investigation uncovered? And what I did with my mother's house. If this story has meant something to you, please share it. There are caregivers watching this right now who have given everything and feel invisible. Let them know someone sees them. The morning after Judge Calloway's ruling, I woke up and did something I hadn't done in almost 2 years. I slept past 6 a.m. My body, which had been running on adrenaline and grief and legal deadlines for so long, finally exhaled. I lay in bed and listened to the birds outside. The roses in the garden were blooming. The Charleston air was warm and sweet and familiar. For the first time since my mother passed, the house felt like home again. Not a battleground. Not a piece of property at the center of a legal dispute. Home. I called Patricia that morning to thank her. She told me I had done the hard part, that the journals, the records, the medical documentation, all of that had been my work, not hers. She said she had simply helped the court see what was already true. I told her I wanted to name my firstborn child after her. She laughed, the first time I had heard her laugh in 4 months. But even in that moment of relief, we both knew it wasn't fully over. The house was mine. The original will was reinstated. But there was still the matter of $147,000. And there was still Ryan. Within 10 days of Judge Calloway's ruling, 2 investigators from the Charleston County Sheriff's Office contacted Patricia's office. South Carolina takes financial elder abuse seriously. It is a felony under state law, and the threshold for prosecution is much lower than people think. You don't have to prove that the victim was completely incapacitated. You simply have to prove that someone used a position of trust to exploit a vulnerable adult for financial gain. The investigators had already begun reviewing the bank records by the time they contacted us. What they found went even further than what Patricia had uncovered during the civil case. The $147,000 in wire transfers was just the beginning. When investigators traced the full financial history of my mother's accounts, going back not 14 months, but 3 years, they found a pattern that made the courtroom evidence look like the surface of something much deeper. 3 years ago, Ryan had convinced my mother to add him as a joint account holder on her primary checking account. He had told her it was for convenience, so he could help manage bills remotely if needed. She had agreed. Because she trusted him. Because he was her son. Over the following 3 years, Ryan had made 67 separate transactions from that account. Total amount, $203,000. Not $147,000. $203,000. My mother's entire life savings, money she and my father had spent decades building, quietly drained away while I was in the next room changing her medications and reading to her and holding her hand. I remember the day Patricia called to tell me the full number. I was standing in the garden. I had been pulling weeds from around my mother's rose bushes, something she had loved to do herself, before her hands stopped cooperating. I stood there in the dirt with my phone pressed to my ear, and I thought about every single thing that money represented. My parents' first home. My father's decades of overtime. My mother's careful, patient saving, the woman who clipped coupons and bought Christmas presents in July to spread out the cost. $203,000. Gone. I set the phone down, and I sat in the garden for a long time. Then I stood back up and kept pulling weeds. Because that's what you do. You keep going. For months after Judge Calloway's ruling, on a Tuesday morning in August, Ryan Michael Hartwell was formally charged with financial exploitation of a vulnerable adult in the state of South Carolina. It is a felony. It carries a sentence of up to 10 years in prison and significant financial penalties. His attorney, the polished, expensive Jeffrey Marsh, entered a not guilty plea on his behalf. I am not going to stand here and tell you I felt triumphant when I heard those words. I felt something much more complicated than triumph. I felt grief. Because Ryan is still my brother. He is still the little boy in the photographs on my mother's mantle, the one in the blue striped shirt at Christmas 1987, the one holding baby me at the hospital, the one standing next to our father at his college graduation. That person existed. And somewhere along the way, through choices I will never fully understand, he became someone else. The criminal case is ongoing as of the time I'm recording this. I am not able to share specific details about the proceedings. But I can tell you that the investigators believe the evidence is substantial. And I can tell you that whatever the court decides, it will be decided by people who have seen the full picture. That is all I ever asked for. The full picture. Harold Simmons, the notary Ryan brought from Colombia, was reported to the South Carolina Secretary of State's office, which oversees notary licensing in the state. A formal complaint was filed documenting his failure to disclose his professional relationship with Ryan, his failure to conduct an independent assessment of my mother's capacity, and his role in executing a document that a judge later ruled was obtained through undue influence. His notary commission was suspended pending investigation. I don't know what ultimately happened to Harold Simmons. I don't spend much time thinking about him. He was, in the end, a small piece of a much larger thing. What I think about is this. Somewhere in South Carolina right now, there is another vulnerable person. Another elderly man or woman in the final chapter of their life. And somewhere near them is someone who sees an opportunity. Harold Simmons was willing to be part of that. I hope the next notary, in the next room, thinks twice. Now the part one know many of you have been waiting for. The house on Magnolia Drive. After the ruling, after the investigators, after the paperwork and the legal fees and the long process of restoring the original will, the house was officially, legally, completely mine. I stood in the living room the day the last document was signed, and I looked at everything my mother had filled that space with. The ceramic rooster on the kitchen windowsill. The cornbread pan on the wall. The photographs on the mantel, my parents' wedding. Our family vacations, Ryan and me as children before any of this happened. The rose garden outside, blooming orange and pink against the Charleston sky. I thought about selling it. I want to be honest about that. The thought crossed my mind more than once. The house carried so much love, but also so much pain. There were nights when I wasn't sure I could separate the two. But then I thought about my mother's hands in that garden. I thought about the Sunday mornings she spent in that kitchen. I thought about every evening we sat together in the living room, watching the Golden Girls and laughing at the same jokes we had laughed at 100 times before. This house is her. Not the legal document someone tried to steal. Not the asset on a balance sheet. Her. And so I stayed. I painted the front door. My mother had always wanted to paint it yellow, and she never got around to it. I painted it yellow the first weekend of September. I planted new tomatoes in the garden, the way she used to. I haven't gotten the hang of it yet. Hers were always better, but I'm learning. I hung a new photo on the mantel. Just my mother and me, from a Sunday afternoon about 4 years ago. She's sitting in her garden chair, and I'm next to her, and we're both squinting into the sun and laughing about something I can't even remember anymore. She looks happy. I look happy. That's the photo I see every morning when I come down the stairs. That's what I chose to keep. Before I say goodbye, I want to talk to someone specific. I want to talk to the caregivers. If you are taking care of a parent right now, a spouse, a sibling, anyone, and you are doing it quietly and without recognition, I want you to hear this. What you are doing matters. I know it doesn't always feel that way. I know there are days when you are exhausted and invisible, and you wonder if anyone sees the weight of what you carry. Someone sees it. Keep records. I cannot say this strongly enough. Keep a journal. Document the medications, the appointments, the good days and the bad days. Not because you're planning for a legal battle, but because those records are a testimony to what you gave. And if something goes wrong, they may be the most important thing you have. Talk to an attorney early if you have concerns about a family member's estate. Don't wait until after the funeral. It is not disloyal to protect the people you love. And please, please know your state's laws on financial elder abuse. In most states, it is a serious crime, and there are people whose entire job is to investigate it. The number for Adult Protective Services in your state is one phone call away. You are not alone in this. And you are not powerless. It is a Sunday morning as I record this. The windows are open. The garden is doing what my mother always said it would do if you just left it alone long enough. It's figuring itself out. The yellow front door is catching the morning light. The ceramic rooster is on the windowsill. And I am sitting at my mother's kitchen table, in my mother's house, in the city where I was born, and for the first time in a very long time, I feel something I had almost forgotten how to feel. Peace. Mom, if there is any part of you that can hear this, I kept the house. I kept the garden. I painted the door yellow, the way you always wanted. I made the cornbread last Sunday. It wasn't as good as yours. It never will be. But I'm learning. Thank you for 10 years of Sunday mornings. Thank you for the stories about Dad I had never heard. Thank you for teaching me that showing up, even when it's hard, especially when it's hard, is the most important thing a person can do. I love you. I'll take good care of the roses. That is the end of Emily Hartwell's story. If this series has meant something to you, if it made you feel seen, or gave you courage or simply kept you company for a few hours, I want to ask you for something. Hit the like button on this video. It takes 1 second, and it helps more people find this story, including caregivers who need to hear it. Leave a comment below. Tell me what you took from this. Tell me your own story if you have one. I read every single comment on this channel, everyone. Share this video with someone who needs it. A caregiver. A friend going through a family dispute. Someone who feels invisible and alone. Sometimes the most powerful thing we can do for another person is say, "Here, this is for you." And subscribe to this channel, Justice Served Tales, so you never miss a story. Every story on this channel is about real people, real moments, and real justice. Stories that remind us that the truth, no matter how long it takes, has a way of coming out. Thank you for being here. Thank you for watching all the way to the end. Until next time, justice will always find its way home.